Okay, here today with Eric Nelson, criminal defense attorney.
Good afternoon.
Eric, we've known each other for quite a long time.
Yeah, I was thinking about that, probably about almost 20 years.
Yeah. And you're, in my opinion, one of the better, most prominent attorneys in town. You've had some pretty big cases.
Well, thank you.
And you're not afraid to take on good cases as you see fit. And we're just going to talk a little bit about your work you do, criminal defense work, how it, what people should know about it
Sure.
if they run into problems. Well, just start out and tell me a brief bit about yourself.
Sure. How far back do you want me to go?
Well, it's totally up to you. I mean, just kind of bring me up to date.
Sure. Born and raised Minneapolis, Minnesota. Did my undergraduate out at a small university in Pennsylvania, Philadelphia, Pennsylvania, called Eastern University. Originally was in the museum business, have a background in history. Not very profitable type of a business, so decided to move back to Minnesota and eventually went to law school at Hamline University.
Okay. And did you start out in criminal defense?
I did a clerkship with a judicial clerkship down in Dakota County right out of law school, just under a year. And then I did a very short stint in divorce and family law and realized that that was a terrible profession, in my opinion, and went into criminal defense.
Okay. Tell me, what part of criminal defense do you like? What part of it really makes you feel good about what you do?
Sure. Well, given the history background, I believe very strongly in the Constitution and the principles that are established by the Constitution. So I feel that I'm actually on a daily basis arguing about and defending the Constitution. That's kind of a global answer. More specifically, the people. We're dealing with people in extremely difficult circumstances and helping them through those circumstances.
Okay. I'm going to ask you a bunch of questions, not necessarily in order of importance or maybe even timeline, but just because I think people find these questions and answers interesting, and I even find them very interesting.
Okay.
Okay. Tell me just explain to me a little bit about the levels of arrest or charges people get that are of significance. I mean, beyond a parking ticket.
Sure.
And how they differ and how they affect people.
Sure. So there's technically 3 levels of crimes in Minnesota if you exclude things like parking tickets. Those are petty misdemeanors and not considered to be crimes. A petty misdemeanor is defined as anything that's punishable by up to a $300 fine. You can't go to jail. When we start talking about crimes, the first level is a misdemeanor. That means simply by statute or by definition, the maximum possible punishment is up to 90 days in jail and or a $1,000 fine. The second level in Minnesota is what's called a gross misdemeanor. That is punishable by up to 1 year in jail and or a $3,000 fine. And anything that is punishable by a year and 1 day, so basically more than a year, up to life imprisonment, is considered a felony.
Okay. Can you give me a couple of examples of what the crimes would be or
Sure.
alleged crimes for each level?
Sure. So first offense DWI, generally speaking, as long as you test under a certain level, is a misdemeanor. First offense domestic assaults, shopliftings, orders for protection violations. Those are all things that would be kind of common examples of misdemeanors, disorderly conduct. Gross misdemeanors might be a second offense DWI. It might be a second offense domestic assault. It could be a first offense DWI with a high alcohol concentration. Those would be gross misdemeanors. Felonies are obviously things like burglary, homicide, most sexual offenses, robbery.
Okay. Have you handled pretty much evenly the full gamut of those?
Yeah, I'd say earlier in my career, mostly misdemeanor type defense, a lot of DWI defense, a lot of domestic defense. So those things are so frequently occurring that there's just more of those things to deal with. As my career has progressed, I have shifted and I handle mostly serious felony level offenses now.
Okay. And what is the percentage, if you could just estimate, that cases that you handle on each, like, let me
Sure.
just say, even more so, arrests that are made based upon that percentage, based upon those different crimes?
Sure. I mean, I'd say the vast majority of crimes that our firm represents would be in the misdemeanor or gross misdemeanor level offense, just because by virtue of the type of those types of cases, there's just more of them. So, for example, there are 30,000 approximately DWIs that occur on an annual basis in the state of Minnesota. Statistically, 1 in every 7 people has a DWI on their record. So that is a very large part of what we would do. Above and beyond that, I would say if you want to break down my personal caseload, I would say probably 80% of my cases are serious felony level offenses, with 20% being more in the misdemeanor.
Okay. How do the, if you know, like nationally, how do those DWIs in Minnesota rank amongst the nation?
I don't know how it stacks up, but I would say it's probably fairly consistent
Okay.
across the states.
Okay. Do the DWIs seem to be a very common situation people are arrested for?
Right.
And you mentioned 1 out of 7. Is that growing or shrinking?
The number of DWI arrests, it's my understanding, that happen annually is decreasing. So I know there was about maybe 2002, 2004, in that era, we had almost 40,000 DWIs in the state of Minnesota. So the number of DWI arrests is actually going down in the state of Minnesota, but the statistics haven't changed that much.
Okay. Let me just shift gears a little bit because I think this is important to a lot of people, a lot of listeners. What are some tips you can give, which I think is probably one of the most important things
Sure.
people want to know prior to it happening, tips you can give them in the event that they're approached or, by the police? Maybe not necessarily even arrested or brought in, taken into custody, but just some things that people should know matter-of-factly that they should do throughout any of those types of situations.
Right. Well, I mean, I obviously think it's very dependent upon every circumstance. Generally speaking, if you are a suspect in a criminal investigation, let's phrase it that way, under no circumstances should you ever think you can talk your way out of it. The Fifth Amendment, the right to remain silent, exists for a very legitimate and important reason. And under no circumstances should you ever talk to the police without a lawyer being present if you're a suspect. If you're just a witness, you have no obligation to cooperate with the police, but obviously, depending on the circumstances, you may choose to do that, and it's a much different analysis. But if you're a suspect, never talk to the police.
Okay. A lot of times, I think people are under the assumption that once they're arrested, let's just say even a domestic situation, that one of the parties that, let's say, is the person who's being assaulted or whatever, can just say, I don't want to press charges.
That's wrong.
Okay.
Yeah.
Do you want to explain that a little bit?
Sure. In Minnesota, Minnesota is what's called an in parens loci state. That means that the state acts in the place of the parent, so to speak. The state of Minnesota, the prosecutor, whether it be a city or county level prosecutor, they make the decision on whether or not to prosecute an individual. Other states do have a complaining witness swear out a complaint, and that's what's required to initiate criminal prosecution. That is not true in Minnesota.
Okay. Let's talk a little bit about the process involved. I mean, I think people who have been in situations where they have to go to court sometimes don't understand what the reasoning is for every step of it, and they wonder why it can't be taken care of quicker.
Mm-hmm. Yeah, I mean, that's probably one of the things that we battle against the most in terms of dealing with our clients, is because people, their lives are often in the balance when you're dealing with criminal prosecutions. And so they want to get things resolved. They want to get things wrapped up as quickly as is possible because they want those answers. What's going to happen? They want to start planning moving forward. the rules of criminal procedure are set up so that there are various stages in the course of a criminal prosecution. Each of those stages has a very important function, even though sometimes your client is like, we were in court for 2 seconds, why, and now we're not going to court for 2 more months, what's going on? But it's just the way the rules are set up the process, and there are important things that occur at each stage, regardless of whether or not it is apparent to the individual.
Do you want to just mention those stages?
Sure.
And just briefly what's involved with those and why they have those?
Yep. So generally the first appearance in most criminal cases is what's called a bail hearing or a first appearance. The bail hearing, if you're arrested, I should back up and tell you that not every criminal prosecution starts with an arrest. Some people are arrested and then they're in jail and they go in front of a judge. That's what I mean as a bail appearance. But a lot of other criminal cases start by what's called summons and complaint, meaning the police were investigating an offense and they've determined charges are warranted, and so a summons and complaint will be sent out to that person ordering them to come to court. So, generally speaking, though, if you're in custody, the first appearance is the bail hearing. That's to establish your conditions of your release, your bail, whatever other orders you may be required to follow during the pendency of the case. From there, you have what's called a Rule 8 hearing, which is the first appearance for your lawyer. Now, oftentimes a lawyer is hired or appointed at that bail appearance, and you may combine those two. But essentially, when someone is arrested and they're released from jail, they want to give the person an opportunity to hire the lawyer that they want. So you move into a Rule 8 hearing, and that's your lawyer's first appearance. The next stage is generally what's called an omnibus hearing. An omnibus hearing is a hearing where the judge has to determine if there's probable cause in gross misdemeanor or felony cases to continue the process. You would also enter a not guilty plea at that point if you're moving forward. You may have then what's called a contested omnibus hearing, where you're challenging various constitutional violations or alleged violations by the police. And then motion hearings, where you're dealing with kind of the rules of engagement of that particular case. So those are called motions in limine, where you are arguing over the specific testimony of witnesses, what can they or can't they say, and then ultimately a jury trial.
Okay. Can somebody come in at the first appearance? Was that
Sure.
okay? And say, let's just say it's a felony charge, so it's fairly serious, and just go walk up there and say, "I'm guilty."
Sure. You can always change your plea at any point. So because the law presumes you innocent and you show up at your first appearance, you can change your plea and plead guilty at a first appearance. Whether or not that's advisable is a whole other question.
Can they plead guilty because they want to protect? They just even say, "I want to plead guilty because I don't want somebody else to get in trouble," or "I didn't really do it, but I just want to get it over with." Or do they have to actually, on the record, state why they're guilty?
They actually, when someone pleads guilty in the state of Minnesota, there's a variety of things the court has to ensure. They have to ensure that the person understands his or her constitutional rights to trials and lawyers and things of that nature. They have to enter what's called a factual basis, meaning the person has to admit facts that, they have to admit what it is that they did in order to make them guilty of a crime. And then, obviously, they have a right of what's called allocution, which is to explain why they're pleading guilty or why they committed the crime or to apologize or to whatever else.
Okay. When people say they're arrested and they get their rights read, and they say you're entitled to an attorney, is everyone entitled to a free attorney?
No.
Okay.
So one clarification or one correction, and it's probably one of the things that TV has miseducated our general population about is when you are arrested, it's not like you see on TV. They don't just slap the cuffs on you and read you your Miranda warning, your rights, so to speak. There is a separate legal analysis to determine whether or not you should be entitled to a Miranda warning. But generally speaking, the question being, is everybody entitled to a free lawyer or a public defender? The answer is no. You have to meet certain financial qualifications in order to be appointed the public defender.
Okay. How many, again, I know you're just, let's talk about your own experience.
Sure.
How many of these cases go to trial? And why would you not go to trial versus trying to settle a case? And what's the reasoning for settling a case?
Sure. I would say, based on my own cases, just kind of doing the quick math in my head, I would say on average I try somewhere between 4 and 6 jury trials per year, which doesn't seem like a lot because I will handle maybe 100 criminal cases in a year. So, I guess what is that, 4%?
Yeah.
4,
Yeah.
right? Not a lot of cases go to trial. There are a percentage of cases that are dismissed before you ever get to trial for some legal ruling or some decision that the court makes that there's certain evidence couldn't be used against the person or whatever the legal ruling is. So there are certain cases that are dismissed. People refer to them as based on technicalities. I prefer based on the Constitution. So there's a number of cases like that. And then the vast majority of criminal cases, 90 to 95% of criminal cases, generally statistically resolve through plea negotiations.
And why is that? I mean, why would somebody want to settle a case, even if they feel that maybe they're guilty?
Right. Well, keep in mind that the state is at least theoretically not allowed to prosecute someone unless they have proof beyond a reasonable doubt that the person committed a crime. So oftentimes people are in fact guilty of these crimes. And so there's a whole multitude of reasons why someone may choose to resolve a case rather than going to trial. Often it is to mitigate or minimize the punishment. That's the most common. If charges could be reduced or lessened, jail time can be reduced, lessened, consequences. Someone is looking at going to prison, and you can negotiate a resolution that results in that person not going to prison. They're going to take advantage of those types of offers.
Okay. You mentioned bail. Let's go back to that. What is the reason for bail?
So bail is essentially to guarantee the person's return to court. It's a way of getting some type of security from the individual that they will return to court. Under the Minnesota Constitution, everyone is entitled as a constitutional right to be free from jail pending the outcome of the criminal case. So if someone has a history of not showing up in court or has some other very serious offense, they want to protect the public, number one, and they want to ensure that that individual is going to come back to court. That's what bail is for, to secure your return.
If I'm right, a lot of people think it's a punishment.
It's not.
Where they say this is how much it is because of, or are there times where will they sometimes say we will not allow bail?
No, not in Minnesota.
So there's always some bail, and it's the amount we're talking about.
Correct.
The different amount. Okay.
And I should clarify, if it is a new criminal case and it's a new charge, then yes, bail is a constitutional right.
Okay. And who decides that? How much it is? The judge?
The judge.
Okay. Do they sometimes is it sometimes you and the prosecutor maybe making an argument to the judge why it should be a certain amount?
Yeah, I mean, that's most common in very serious felony offenses. So if someone is arrested, just pick an offense, let's say on a rape charge, all right? We call it criminal sexual conduct in Minnesota. The court will get information from the Pretrial Probation services saying, here is what this person is looking at if they were to be convicted. Here's their past history of crimes. Here is where they've lived, how long they've lived there, here's who they live with. And so they're looking at a person's connections to the state of Minnesota, to see, is this person a flight risk, essentially, and what danger to the public does this person present. Then there's sort of a mathematical equation that gets applied, and a bail is recommended to the court. The prosecutor and I oftentimes, or the prosecutor and the defense oftentimes, will argue to the judge about what the correct bail amount is. And then the judge ultimately decides the amount of bail to set. There are two different, and I may be rambling on here, but there are two different ways the court can handle it. They can set strictly an unconditional cash amount of bail. And those things are determined sometimes by statute, sometimes they are, they're not. I'm trying to think of the best way to say this, sorry. So again, say for example, you're arrested for a DWI, and it's your first offense, but you tested at a very high level. The statute says that the $12,000 is the maximum bail that the court can impose, and on an unconditional basis. So the person can post bail of $12,000 and get out of jail without any conditions or limitations on his or her freedom. The court can also impose $0, but then give that person a list of conditions that they have to satisfy while the case is pending. So they could say, you're not allowed to drink, you have to be randomly tested, you're not allowed to leave the state of Minnesota, or whatever other conditions they may impose. That's called a conditional bail. So the court is always going to impose an unconditional bail. That's just an amount of money to pay, no other limitations, or a conditional bail. And
Could it be a combination?
No, well, it's an either-or proposition.
Okay, all right.
Yep.
I'm not sure how much you deal with this, but a lot of times you hear they say cash or bond, and they say sometimes you can put up 10% with the court, or
Right.
obviously you can go to bail bondsman. But how does the court in Minnesota handle those types of things?
So let's just pick an arbitrary number. If bail gets set in the amount of $10,000, the individual can literally take $10,000 cash, put it in the court's bank account, basically, deposit it with the court, and the court holds on to it until the case is over.
Okay. And however they get that doesn't matter, and the court just wants all the money. And not everybody can get a bond.
Right.
I'm guessing, but they can try.
Yeah, not everybody has, most people don't have $10,000 cash that they can tie up, for 6 months to a year. So they will hire a bail bondsman. A bail bondsman charges a 10% premium. So in that $10,000 analysis, you'd pay a bail bondsman you'd pay a bail bondsman $1,000.
Okay.
And then they basically are loaning you. The difference is if you use your own actual cash at the end of the case, you get all $10,000 back. If you hire a bail bondsman, you pay the bail bondsman the 10%.
Okay. And if you don't show up to court,
Then you got to pay the bail bondsman the 10 grand.
and even if what about the court? If you put it up with the court itself, just your
Then,
own
then
money?
they can forfeit and keep that money.
Okay. Even if you appear later or they catch you and bring you in?
Yeah, you can make a motion to have that reinstated or have that money given back to you. But it, again, like most things in the law, it really depends, right? Isn't that what we all learn in law school? The answer to any question is it depends. So there's a variety of factors. Have you absconded for 10 years or 10 days, right? How long have you been gone? What were the original charges? So
Okay. You mentioned probation. There's probation that goes on with prior to the guilty plea or sentencing and or found guilty in a trial. So prior to that, how does that probation work?
Sure. So
And what's the purpose of it?
Sure. So probation takes two forms. One is a pretrial probation, and second is a post-sentencing probation. Pretrial probation is really just to monitor a person's compliance with the court-ordered conditions leading up to trial. So if a judge orders you not to drink and to submit to random testing, that pretrial probation officer will be the one that you're dealing with to have your, to do your breath tests or your blood tests or whatever it is. After the fact, then you get assigned a probation. So after you're convicted, you would be assigned a probation officer. Again, that person's job is to monitor your compliance with the court's conditions or sentencing orders.
Okay. Let's talk about sentencing. Let's talk about sentencing in a settlement versus a trial. And I think sometimes the notion is that if you go to trial versus settling, you might get a harsher sentence if you're found guilty. Sometimes maybe that's hard to know. But tell me a little bit about sentencing in general and then how it differs maybe from a settlement and a trial.
Right. So the law basically states that you have a constitutional right to a trial. So you can never be punished for exercising your rights, meaning you can never be punished more harshly than the law would allow simply because you exercised your right to a trial and held the state to its burden. Usually, I think perhaps the reason this perspective or this is kind of developed is, before trial ever occurs, the state may offer somebody a deal, right? You serve X number of months in prison or you serve X number of days in jail, even though the law says you should go to jail for longer or prison for longer. So by way of example, let's assume the law says someone is supposed to serve 3 years in prison as a result of whatever crime it is they committed. And the prosecutor will come to that person beforehand and say, well, I want to get this case resolved. I think I got a strong case, but your guy's a nice guy. He's done everything he was supposed to do up to this point. So I'll offer him 2 years in prison. And the person says no, they go to trial, and all of a sudden now they're getting sentenced to 3 years, right? So it seems like it's more serious, but that's what the law said they should have done in the first place.
Okay.
So the other thing to understand, at least with respect to felony sentencing in Minnesota, is that Minnesota has what's called a determinative sentencing guidelines, or a determinative sentencing structure. What that means is, at least in theory, that every crime or every felony level offense in Minnesota is ranked in terms of its severity. And you look at the grid, we call it the sentencing guidelines grid, and you see where that offense is ranked. And then you look at the person's prior criminal history, and where those two axes intersect, it creates a presumption of that's the sentence the person is supposed to serve. So the idea, at least theoretically, is we treat everybody equally, right? So regardless of whether you're white or black or a man or a woman or, insert whichever subgroup you want, if you commit a particular crime, you do a certain amount of time. That's the theory.
Okay. And can judges deviate from that?
They can. They can go downward on the basis of a defendant's motion. So if there are mitigating factors that the court finds, they can reduce that sentence. That's called a durational departure. Or they could do what's called a dispositional departure, which is where the court says, we're not going to send you to prison, we're going to just put you on probation. If the court is going to go higher than the guidelines, I think it was about 2005, the United States Supreme Court said that that's up to a jury. So now what happens in Minnesota, if the presumptive sentence for a particular crime is, say, 6 years or 5 years in prison, and the prosecutor wants to try to get more time than that, they have to file what's called a Blakely motion, which is a motion to say these are the aggravating factors. These are the things that we think make this case more serious than the law recognizes in the sentencing guidelines. And then a jury has to decide beyond a reasonable doubt whether those factors exist.
Is that like a second trial almost?
It
with
is.
a separate jury?
Nope, it's with the same jury. It's called a bifurcated trial. The first question is is the person guilty or not guilty, right? So the jury will determine the person's guilt. If they find the person guilty, then they're sent back in, and you have sort of a second mini trial where you're arguing over these aggravating factors.
Okay. In a trial itself, why and why not would a defendant testify?
Sure. That is really a case-by-case analysis. And it's one of the things that I always tell my client is in a trial situation, there are literally hundreds of decisions that get made, oftentimes, in a second. Strategy, those types of things, that's the lawyer's job, to determine the strategy of the case. But a person has what are called individual or personal rights. And one of those personal rights is whether they testify or not in trial. That is the client, the defendant's right. Nobody can force him. Even if I say it's a bad idea, you shouldn't testify, and my client wants to testify, I have to honor that. So it's the individual's right to decide if they're going to or not. Why would you? Why wouldn't you? Obviously, if you did not commit the crime that you are accused of, juries often would like to hear you say, I did not commit this crime. They want to hear your explanation, Why shouldn't you testify? Well, you have to understand you'll be subject to cross-examination. Anything that you say that's inconsistent with other evidence is going to be pointed out. You're going to be, attacked by the state. So
Okay.
It really is a case-by-case basis.
Okay. Now we're into jury trials a little bit. Evidence. A lot of these questions are based upon what people's ideas from watching TV, because most
Right.
people aren't in trials, they're not arrested, they don't deal with this. As far as evidence goes, is there any hidden evidence that the prosecutor has, the defendant has, or does everybody have the same information?
Everybody has the same information. It is exceptionally rare when sort of the the last minute evidence gets walked into court, and that would be highly unusual. There is an ongoing process called the discovery process, that when someone is charged with a crime, they have a right to get access to all of the state's evidence. So the state of Minnesota, the prosecutor, has an obligation to provide you with this discovery information. That can be police reports, it can be forensic testing results, it can be witness statements, photographs, you name it, body camera footage, squad car footage, whatever the evidence is, so to speak, in any particular case. You get to see all of that information, all of that evidence before you ever go to trial. And if that last minute piece of evidence somehow comes up, oftentimes the remedy is, well, we're not going to try the case now. We're going to give everybody an opportunity to look at this new evidence and make decisions based on it.
So it's put on hold essentially?
Correct.
You still keep the same jury and...
Well, if it's in the middle of an actual trial, it would be unlikely that evidence would be admitted into court.
Okay, you're talking previous to the...
Leading up to a trial.
I see,
Yeah.
okay. And what about situations similar to that if all of a sudden a witness decides to come forward or decides to testify, either for the defense or the prosecution?
Sure. That's probably a little bit more of a likely scenario where someone who previously didn't want to testify now agrees to testify. Again, the idea is that everyone is entitled to a fair trial, and so everyone is given an opportunity to kind of look at what this person's going to say, hear what they're going to say before you would ever have that person testify in front of a jury. If it comes up in the middle of a trial, we can always press pause on the trial. It wouldn't be for a week or 2 weeks or anything like that. It might be for an hour, half an hour, just to give people the time to kind of digest the information.
Based on witnesses that testify, a lot of times you hear that you're under oath, subject to perjury charges. How often do people actually get prosecuted for perjury? I mean, do they?
It's infrequent. They do.
Okay.
I have definitely seen it happen. I don't know that I've ever seen it perjury. Perjury is a broad category, and perjury can be, you fill out an application for public assistance and you don't disclose some asset. That's perjury because you're signing it under the penalty of perjury. So that's the more likely types of perjury charges you would see. So perjury in an application of some sort that requires an oath, perjury in an affidavit. I don't know that in my career, I don't know that I've ever seen someone who's testified falsely ever be prosecuted. I'm sure it happens, but it's pretty rare.
Is it brought up, though, to the witness sometimes?
Sure.
Okay.
Yeah, anytime they take the oath, right? They're reminded, you swear to tell the truth under the penalty of perjury.
Okay, all right. When a jury, when the case is over, whether it be guilty or not guilty, is the prosecutor or the defense attorney allowed to talk to the jury after the case is over?
Yeah, once the case is over, you can always talk to the jury. They don't have to talk to you, but you can always attempt.
And what would be the reasoning for that?
To talk to the jury?
Yeah.
Well, I guess it depends if you won or lost, right?
Right. Okay.
You want to see what was effective. You want to ask them why they made the decision. What was the thought process of the jury? From a lawyer standpoint, it's one of those things that, you try to learn. Every time I try a case, I try to say, what did I learn from this experience and how can I do it differently or better or more effectively the next time?
Okay. And are some of the jury members cooperative?
Oh, yeah.
Okay.
The jury process is a really interesting thing because usually at the beginning of a trial and you're selecting a jury, you get a sense of who wants to be there and who doesn't want to be there. And the majority of people are really either indifferent or pretty opposed to being there. They think it's a major inconvenience. They don't really want to be a part of it. By the end of the trial, people just, they can't rave about the experience. They can't rave enough about the experience because it was so positive. They get to actually see how this works. It's much more than theoretical at that point, right? It's reality. The last trial I tried just last month, the jury, once the verdicts were announced, they wept. They started crying. It's an incredibly emotional experience for people, especially in more serious cases. And I know that jurors have met and fallen in love. I know jurors who have, formed friendships, and they continue to get together to, talk and socialize. So it's a really positive experience. Yeah, certainly it's an inconvenience and it's not always enjoyable, but.
I hear a lot about people who are called for jury or potentially called for jury duty. Mm-hmm. And they always hear from novices or other people that say, oh, just go in there and tell them you're prejudiced. Just tell them that you think the person's guilty. Or I think, they come up with all these sort of things they think they can say that will basically get them ejected from the jury.
Yep.
Is that true?
You see it all the time. People who come in and say, it actually happened in this last trial again. We did what was called a questionnaire beforehand. My client was African American, and there was a question on the questionnaire asking about race, and you could tell that this individual, he wrote answers like, I believe that they're cheap, or whatever his racially biased statements were. But I don't think he ever expected to be called out on it, right? Because we bring him out into the courtroom, and now in front of a large group of people, we're calling you out on your stereotypes. And obviously he wasn't selected for this trial, but just because you're not selected on this case, it doesn't mean that you're not going to now end up in some insurance fraud trial that has, some civil, a slip and fall. They're going to keep you working until they find a trial for you or they send you home.
Okay. But that doesn't always work.
No.
Okay. Because, like you said, when you talk to them, sometimes you kind of see, or, I guess both sides may or may not see that It's a ploy to get out of it.
Yeah. I don't know if I can swear on this podcast, but you can usually sense when someone is bullshitting.
Okay.
Because it's, their answers don't make sense, and it just looks like it's just an effort to get out of the jury service.
Okay, that makes sense. Often you hear people say who are arrested, I'm going to sue you for unlawful arrest, or even, you can talk about that, or you can talk about after a trial if they're found not guilty, or even if somebody's put in prison, and later on it finds out they're not guilty.
Right.
Just generally, what's the situation for those particular scenarios? Mm-hmm. Not necessarily civil rights issues, but sentencing issues or not guilty
Yeah, I mean, I think it really falls into one of two categories. Either is a it's a post conviction relief type of a case, meaning that someone who was acquitted, or excuse me, someone who was convicted of a crime, and it turns out that later there's evidence that shows they're innocent. There's a process built into the law for post conviction relief. There's rules on when it can and when it's supposed to be, and what are the bases for post conviction relief. But it's basically just to secure the person's freedom. The other types of cases are the more civil rights violations, the police misconduct cases. It's called a 1983 action. I don't handle those personally, but those are actions where you sue the police for a violation of your civil rights.
Okay. But if you're found, for example, you're arrested, you're brought in, you're put in jail while pending a trial, for example, even if there's bail, and then they just release you, okay? There's bad publicity, let's say, if there's somebody, they have some notoriety and so forth. Do they have a shot if they were to sue the police to get compensation?
Again, that's not my expertise.
Okay.
It falls into the 1983 actions for malicious prosecution. I mean, I know that there was that case up in St. Cloud where the guy was arrested for shooting the police officer, and it turns out he didn't shoot the police officer.
Okay.
And I think he sued Care 11 and various other the police. I don't know what happened.
Yeah.
But I know that people try.
But that does
It does happen.
But it doesn't deter the police when they're yelling, "I'm
No.
going to sue you."
No, it does not deter the police to tell them that you're going to sue them.
Okay. Tell me, I don't need to hear about specific cases, but just tell me some interesting things that you've come across that, listeners would be interested in hearing about.
Yeah, I mean, it's kind of an interesting profession, because inevitably, whenever someone learns that you're a criminal defense attorney, the first question is always, how can you do that?
I hear that a lot from people
about lawyers, I suppose, in general, but particularly criminal defense lawyers. And then the second question is, tell us some cool stories. I deal with what we deal with, and particularly those of us who deal with violent offenses, homicides, sexual assaults, child pornography. You're dealing with some incredibly difficult subjects. You're dealing with, it can be an emotionally exhausting career. And you're dealing with people who have struggled with addiction. You're dealing with whether that be a sexual addiction or a drug addiction or an alcohol addiction. So you're dealing with a lot of high stress, high stakes type of stuff. Great story, there's lots of fun stories you can tell at cocktail parties, about weird things that have happened. And you honestly can say, I never thought that you could say I thought I'd seen it all, and something new comes along.
Right. Right.
The people's, whether it be depraved behaviors or whatever it is. A lot of people ask me about homicide cases and, like child pornography cases, for example. Little do people know is that I, as the lawyer, have to go and inspect the child pornography. And I don't do it in every single case. I have a way of getting my client to tell me whether I need to do this or not. But just earlier this week, I had to go down to the county attorney's office and view child pornography.
Well, that's got to be.
It's tough.
Yeah.
I've got children. I've got 3 kids, and and I've coached youth sports,
Sure.
and I love my kids, and I've worked with children in past lives, and it's a very tough type of a thing, but something we have to deal with.
Right.
And that usually causes the question of how can you do what it is you do.
Right. You have to remove yourself, I'm guessing, from that part of it, but still do the right thing for your client.
Yeah, you have every single person has a constitutional right to a good defense, right? To a defense. And I take that extremely seriously, and so I'm going to do whatever I have to do to ethically to defend you.
And I say a lot of times when I hear these stories about how can you defend that kind of person. I think the idea is that I convey to them, if if they weren't able to get a defense, you may not be able to get a defense if you
Right.
needed it.
Yeah, I mean that really is people don't think about it in the general sense. They think about it in the individual sense. So what I described with some of these jurors when they see how it applies, right? This case I just tried was a personal care attendant who was charged with sexually assaulting one of his patients, and there was eyewitness and DNA and all of this stuff, and and some of the jurors commented to me after about how eye-opening of an experience it was to see how the police do things, how this process works, how the law works. So when you think about it, people don't generally think about it in the abstract. They think about it only when it hits them, and most people never get charged with the crime, so they don't spend much time thinking about it. But it is definitely true that if one person is not afforded their constitutional rights, then it minimizes the significance of those rights for all involved.
And I think you would agree with me that unless you go to law school, most people don't have a real, idea about what goes on or, things. So it probably would be a good idea that in high schools that they taught a little bit more about the process, and maybe had classes on them, or a class where an attorney comes in and talks to them, because they're never really going to get a handle on like what we're talking about today,
Right.
which I think is really important.
Yeah, I mean, and that's one of the things I do is I wear many hats in my career, right? Is I don't only I'm on a panel, for example, of criminal defense lawyers who represent police officers when they are accused of criminal action. So anytime a police officer shoots someone, that becomes a criminal investigation. And so they are given a criminal defense lawyer through their union. So I'm on a panel of that, so how can I defend criminals and cops? I teach regularly at, I shouldn't say teach, I speak regularly at high schools. I have several teachers that I work with that invite me into their government classes to try to communicate these ideas. And I think that, I think, as you know, I represented Amy Sensor in her criminal case. And in the course of that, you saw how, if you paid any attention to that case, how much public discourse there was about that particular case, and how strong people's opinions became. But realistically, I guess the frustrating thing about it is you see how little people really truly understand the process. And I wish there was a way to effectively communicate that to the non-lawyer.
I think a lot of people, they're understanding the laws from TV shows,
Right.
and from the press. And I don't think they get enough understanding. It's just not enough for them to digest and really understand the whole process.
Yeah, and I think that perhaps is why so many jurors walk out of that experience kind of, like they said, having their eyes open to the process and how it works. And, remember how important that duty is that everybody has.
And I want to just say, Eric, I think you've really given a lot of good information to people and listeners who will find this valuable, because you've made it simple for people to understand, and hopefully they can stay out of trouble. But it gives them a way to understand what would happen if they get in trouble and what they should do as far as contacting an attorney and handling themselves in a situation prior to contacting an attorney.
Yeah, every time I wrap up a criminal case, I shake my client's hands and I say, don't take offense, but I hope I never see you again.
That's right. So. That's right. Okay. Well,
right.
Thanks very much, and appreciate you being here.
No problem.